everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with termination rights for a buyer based on the national emergency that has been declared due to the pandemic of coronavirus and the health threat of COVID-19. So the question is, the question is, if a buyer is outside of all their contingencies, may the buyer terminate the contract using other lawful reason? The country has been declared a state of national emergency, and protect their earnest money. And the answer is, it depends. And I want to thank all of our affiliated closing attorneys with providing me with legal guidance and contractual guidance on this issue. I want to thank Andy Hartman. I want to thank Amy Davis. I want to thank Doug Dean, and I want to thank Sean Horan. And I will link all of their contact information below. But basically, it depends on the contract and what verbiage is. So if a buyer and a seller are binding under either the GAR, Georgia Association of REALTORS contract, or the RE forms contract form, then if a buyer wants to terminate and their financing contingencies and all their contingencies are over, they will be in default of the contract. Let me give you a couple of scenarios where the COVID-19 virus is having an effect specifically on the financing. For example, let's say a buyer has been fully approved, their financing contingency has expired, and then they are laid off from their job. And so by the time they got laid off until they close, they are not going to meet the financing contingency, so their loan is going to be denied. Another scenario would be, for example, jumbo loan, and the lender who was lending the jumbo loan money, that financing is no longer in existence because of what's going on related to coronavirus and the world markets and what's going on in the world based on this pandemic. Again, the contractual answer is you have to go back to the contract. And so the reason I say it depends is GAR, the Georgia Association of REALTORS, has come up with a COVID-19 special stipulation that you would use when negotiating a contract, or obviously you would use that verbiage in an amendment if the parties are already binding. Please see the last video I did for that verbiage and all the explanation from the Georgia Association of REALTORS on that COVID-19 special stipulation. If you are a Maximum One agent, it is contained in the reference section of Paperless Pipeline. So if a contract has that verbiage in it, then it still depends. It's still that GAR special stipulation, the COVID-19 special stipulation, still does not give blanket termination rights to any party. It just gives extension rights, and you'll have to read through that. But the contract issue I want to talk to you about is a clause called force majeure. And basically, even though it seems crazy, it's important to remember that the GAR contract and the RE forms contract does not contain a force majeure clause. And basically what that force majeure clause, it says, if there is a war or major natural disaster like a flood or hurricane or a worldwide pandemic, which makes it impossible or impractical for one or more of the parties to perform under the contract, then either party may terminate without consequence. That's the force majeure clause. That clause is not contained in GAR and not contained in the RE forms. Now, again, what about if the COVID-19 special stip has been used? Again, we'll have to take a look at that depending on why or how one of the parties is terminating. You know, is a buyer terminating because of they're just freaked out and they're fearful and don't want to do anything right now? Or is it specifically related to a COVID-19 related event that GAR is calling a CRE event that renders a buyer or a seller unable to perform their actual obligations per the contract? But basically right now, without that force majeure clause, nope, if a buyer terminates outside of all of their contingencies, they would lose their earnest money. Now, of course, a buyer would send over a termination and release agreement. There is nothing that would prevent a seller from agreeing to give a buyer back their earnest money. And the holder of the earnest money must act based on how they are directed by agreement between the buyer and the seller. So if we're holding earnest money, or any holder holding earnest money, and we get a fully executed termination and release agreement with the parties agreeing for the earnest money to go back to the buyer, then of course, regardless of any circumstance or reason, the holder would disperse those funds back to the buyer. Buyer and seller can agree to split the funds. They can do whatever they want. The holder must act on agreement that evidenced by their signatures, instructing the holder what to do with those funds. In the case where we don't have a fully executed agreement to release the funds, and the holder would have to make an interpretation of the contract, even with all this craziness going on, we still have to go by the terms of the contract. And if that force majeure clause is not in there, then the buyer would be in default. Now, how will all of this play out in the future? Who knows? Will there be some court cases, some case law, or some judges overturning these issues? Who knows? This is an unprecedented time, at least during my lifetime. Maybe not for others, but I believe it is an unprecedented time. And I want to thank Sean Horan for bringing up another issue, which is called Principle of Equity in Law, that does talk about who is harmed by no fault of their own. For example, should a buyer be penalized because we are in a state of a national emergency? And again, we have never been in a national emergency during my lifetime. And due to that national emergency, resulting in the buyer's inability to close, should that buyer lose their earnest money? On the flip side of it, what about these sellers? The sellers could also be harmed economically. What if they, by the failure to close from the buyer, having to terminate based on an issue outside of all of their contractual contingencies? What if a seller all of a sudden endures the financial hardship of having to pay 2 mortgages, or having to default on another contract, so forth and so on? So again, there is that other legal principle called equity of law. How will that get determined? I don't know. I'm not a judge and I'm not an attorney, and that may come up in the future. But as of right now, we have to go by the contract. Will GAR add in a force majeure clause? Will the RE forms add in a force majeure clause moving forward? Who knows? That will be up to those forms committees. So what do you do as an agent? Well, right now, if one of the parties has to terminate, the best thing to do would be to try and get the buyer and the seller to come to an agreement on their own regarding the disbursement of the earnest money, and signing the TNR directing the holder how to release those funds and to which party. We've had some sellers that are also choosing to terminate contracts just to kind of catch their breath, and a lot of things going on. Same thing, unless there was a provision for seller termination rights without penalty, the seller would be in default of the contract, and then the parties need to look to the terms of the contract for the remedies for default. Again, all of this gets thrown out the window if a buyer and a seller agree on that agreement to release what the holder is to do with the earnest money. Now, a couple of things. If you guys are using the RE contract forms, please make sure that you attach the standard terms and reference them as an exhibit. If you are a maximum one agent, that is our policy that you do that. There is verbiage in the RE Forms purchase and sale agreement that they are referenced even though they are online. Again, every agent, I don't really care who your broker is, you need to make sure that the parties are well informed and you've done everything within your power to make sure they understand the standard terms that go with the RE Forms contract is available to you wherever you pull up your contract forms. Again, maximum one agents, it is our policy that you attach those and reference them as an exhibit. Now, one other thing, we're having a whole lot of iBuyer contracts where the iBuyer is buying a seller's property and they are terminating. The iBuyers are terminating right and left, and they are leaving our sellers high and dry. And a lot of these contracts, unfortunately, are domino contracts where a person, let's say a public seller, has sold to an iBuyer. The iBuyer's the buyer, and then the seller, as soon as they close this one, I'm going to buy another one. And those iBuyers are terminating those contracts right and left, leaving our public high and dry and in a really bad contractual situation, and basically almost creating a situation where they are having to default on the house they're buying. What about those contracts? Well, the majority of those iBuyer contracts do have a force majeure clause in there that does allow these iBuyer contracts to terminate without penalty. So without penalty means they would get their earnest money back. So if you're binding on any other contract, make sure to look for that clause. Please check with your broker or a closing attorney. Again, I want to thank Andy Hartman, Amy Davis, Doug Dean, Sean Horan. Thank you guys so much for guiding us through this legal issue, this legal contractual clause of force majeure, and helping us as brokers to understand that even in these crazy times, you still have to go by the contract and what the buyer and the seller have agreed to contractually. So thank you guys so much for watching. Again, please watch the previous video where I go a little bit more in depth into the GAR COVID-19 special stipulation. There are many buyers and sellers out there that still need your help. So please continue to be a blessing to our buying and selling public and help them get together and convey property. And thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.